Ladies and gentlemen, if you truly care about the survival of American institutions, the courts, the Constitution, the very fabric of our democracy, then buckle up and pay close attention to what I'm about to lay out for you. This isn't just another legal headline buried in the back pages of a newspaper. No, what unfolded today in a federal courtroom in Manhattan is nothing short of a high-stakes drama that tests the limits of our system. It's a moment where the rules we all live by were pushed to the brink, and one man's legal team decided they simply didn't apply. Subscribe to this channel right now, turn on those notifications, and let's dive in because the devil is in the details. And those details could change everything. Picture this. It's approximately 11:47 a.m. in the Southern District of New York, inside the Thurgood Marshall United States Courthouse. The air is thick with tension, the kind you feel in a thriller movie right before the plot twists. In the midst of active federal court proceedings, with witnesses, evidence, and the weight of justice hanging in the balance, three of the most elite, highest-paid defense attorneys in the country suddenly stand up from the counsel table. They gather their stacks of papers, briefcases in hand, and make a beeline for the exit, all while the federal judge is mid-sentence, her words hanging unfinished in the air. Let me repeat that so it really sinks in. These are licensed officers of the court, sworn under oath to uphold the United States Constitution. They're not random protesters or disgruntled spectators. They're professionals bound by ethics and law. Yet, here they were, attempting to physically abandon their client, former President Donald Trump, and flee an ongoing federal proceeding simply because they disagreed with a ruling. This isn't hyperbole. It's a direct challenge to the authority of the court. And what happened next? Something so rare it hasn't been seen in a federal courthouse in over 2 decades. We're talking about a standoff that could rewrite the playbook on courtroom conduct. To understand why this is such a bombshell, we need to rewind and unpack the sequence of events step by step. The details aren't just filler, they're the foundation of why this matters for every American, regardless of political affiliation. The morning session kicked off with what seasoned court observers called routine procedural wrangling. The prosecution was pushing to admit a trove of financial documents into evidence. The defense naturally was objecting vigorously. This is par for the course in a high-profile white-collar criminal case like this one, where complexity is the name of the game. Think thousands of pages, intricate financial trails, and arguments that could drag on for hours. But here's the crucial context you need to grasp. Just 48 hours prior to this hearing, a bombshell dropped, albeit briefly, due to what sources describe as a clerical error in the federal court's electronic filing system, known as PACER, Public Access to Court Electronic Records. A sealed filing, meant to be hidden from public view, was accidentally uploaded and visible for exactly 17 minutes before being yanked offline. In that narrow window, eagle-eyed legal researchers and journalists captured screenshots and downloads. What was in it? According to multiple independent sources who reviewed the documents, the prosecution had submitted fresh evidence. Encrypted communications between Trump and his co-defendants during a period the defense had previously sworn was a blackout, no contact whatsoever. These weren't just casual texts or emails. We're talking about alleged wire transfers amounting to a staggering $4.7 million, along with what one insider called the most damaging paper trail ever assembled in a white-collar criminal case. Imagine ledgers, bank statements, and digital footprints that could tie together a web of financial improprieties. This evidence, if admitted, could be the smoking gun prosecutors have been chasing. And this morning, Judge Patricia Caldwell, a veteran on the bench, ruled that all 847 pages were admissible. Boom. That's when the courtroom erupted into chaos. Lead attorney Robert Sterling, a powerhouse litigator known for defending Fortune 500 executives, rose from the counsel table. The court reporter, Maria Rodriguez, captured his words verbatim for the official transcript. Your Honor, this court has abandoned all pretense of impartiality. We cannot and will not participate in what has become a predetermined show trial. His co-counsel, Jennifer Matthews, a sharp-tongued strategist with a track record in political cases, chimed in, "This is prosecutorial misconduct at its worst, and we refuse to legitimize it with our presence." And with that, they pivoted toward the door, papers in tow, as if exiting a bad meeting rather than a federal trial. Now, pause for a second and let's analyze this moment. In legal terms, what they were attempting is akin to mutiny on a ship. Attorneys can't just bail when things get tough. They're ethically obligated to represent their client zealously, but within the rules. The American Bar Association's Model Rules of Professional Conduct, Rule 1.16, allows withdrawal only under specific circumstances, like if continued representation would violate the law or if the client insists on unethical actions. But mid-trial abandonment? That's rare and requires court approval. Historically, such moves have led to sanctions, as seen in the 1,972nd Chicago 7 trial, where defense attorneys' disruptive behavior resulted in contempt charges. Here, the attorneys' statements suggest they viewed the ruling as biased, but critics argue it was a calculated ploy to force a mistrial. To make this more informative, let's break down admissible evidence. In federal courts, under the Federal Rules of Evidence, Rule 401 to 403, evidence must be relevant, not unduly prejudicial, and authenticated. The defense likely argued these documents were hearsay or obtained improperly, but Judge Caldwell disagreed. Her decision could hinge on chain of custody proofs or expert testimony on encryption. If you're new to this, think of it like a referee in a football game allowing a replay review. Once it's in, it changes the score. Back to the drama. Who is Judge Patricia Caldwell? She's no novice. Appointed by President Ronald Reagan in 1995, she's served 31 years on the federal bench. Known for her even-keeled demeanor, she's presided over everything from corporate fraud to terrorism cases. Defense attorneys often breathe a sigh of relief when assigned to her courtroom because she runs a tight but fair ship. No favoritism, no histrionics. So, when these three attorneys tried to walk out, her response was measured but firm, and it sent shockwaves through the legal world. Looking directly at them, she declared, "Counselors, if you take one more step toward that door, I will hold you in criminal contempt and issue bench warrants for your immediate arrest." She then directed the U.S. Marshals to secure the exits. Within seconds, 6 armed federal marshals, trained professionals who protect the judiciary, positioned themselves at every door. The courtroom froze. The standoff, it lasted precisely 7 minutes and 23 seconds, according to the official record. During that time, no one moved. The tension was palpable. You could hear a pin drop amid the rustling of papers and whispers from spectators. If this story is gripping you, and it should, because it's about the bedrock of our justice system, hit that like button now. But let's not stop at the surface. Why were Trump's attorneys so desperate to bolt? Sources with direct knowledge of the proceedings reveal that just before the walkout, Judge Caldwell had disclosed something explosive. She'd received a sealed ex parte submission from the Department of Justice that very morning. For the uninitiated, let's unpack ex parte. In Latin, it means from one party, referring to communications where only one side hear. The prosecution submits information to the judge without the other's knowledge. Federal courts rarely allow this. It's reserved for ultra-sensitive matters like national security threats, witness safety, or classified intelligence. Under Federal Rule of Criminal Procedure 12.3, ex parte filings must be justified, and the judge decides if they're warranted. In high-profile cases, they've been used in trials involving mafia informants or espionage, where revealing details could endanger lives. Judge Caldwell stated on the record that, based on this filing, she was contemplating enhanced security measures and possibly sequestering the jury, isolating them from outside influences to prevent tampering. To any seasoned criminal defense attorney, this screamed one thing: the prosecution has a cooperating witness. Someone from Trump's inner circle has flipped, agreeing to testify in exchange for leniency or protection. Former federal prosecutor Andrew McCarthy, in a rapid-fire interview on Fox News hours later, put it bluntly: when defense attorneys hear about a sealed ex parte submission in a case of this magnitude, they know the walls are closing in. Someone on the inside has turned, and they're about to drop a bomb the defense never saw coming. The panic suddenly makes complete sense. McCarthy, who prosecuted the 1993 World Trade Center bombing, knows the game inside out. His analysis aligns with historical precedents, like in the Enron scandal where executives flipped, leading to convictions. Now, let's connect the dots, because this is where the story transcends legal jargon and enters the realm of national consequence. Court documents filed shortly after the standoff show that within 30 minutes of returning to their seats, Sterling's team submitted an emergency motion for a mistrial, alleging judicial bias and prosecutorial misconduct. They also moved to recuse Judge Caldwell, claiming her threat of arrest showed personal animus toward the defense. Do you see the strategy here? By staging this dramatic spectacle, standing up, declaring the trial rigged, and attempting to leave, they've potentially manufactured grounds for appeals. In appellate courts, under standards from cases like Strickland versus Washington, 1984, ineffective assistance or biased proceedings can overturn verdicts. Legal experts across the spectrum agree. This was theater, scripted for an audience beyond the jury box. Evidence of coordination? Sources report Fox News camera crews were stationed outside the courthouse 45 minutes before the incident. Conservative commentators tweeted about judicial tyranny before the news broke publicly. How did they know? This raises eyebrows about media orchestration. In political science terms, it's agenda setting, using events to shape narratives. Recall the January 6th hearings, where timing and media played key roles. If true, this walkout wasn't spontaneous. It was a PR stunt. Subscribe if you want to follow this thread, because the implications are staggering. That sealed ex parte submission, DOJ insiders hint it relates to testimony from Witness 14, slated for next Tuesday. This person per court filings has firsthand knowledge of the core financial transactions. They've been in protective custody since October. Think witness protection program levels, with U.S. Marshals guarding them 24/7. Such protection is typically for organized crime or high-threat cases, like the Sammy the Bull Gravano flip against John Gotti in the 1990 seconds. Speculation on Witness 14's identity runs rampant among legal analysts. The top theory, a former CFO or financial controller from Trump's organization, someone with access to ledgers and transfers. Protective custody implies real danger, perhaps threats from loyalists. If this witness testifies as expected, it could dismantle the defense's narrative, providing irrefutable links to alleged fraud. Post-standoff, Judge Caldwell dropped another bombshell. Given counsel's attempted abandonment of their client mid-trial, I am considering appointing shadow counsel to ensure the defendant's Sixth Amendment rights are protected. Shadow counsel? It's like having backup singers ready to jump in if the lead falters. In practice, it means court-appointed attorneys sit at the table, prepared to take over. This is rare but not unprecedented. It was used in the 2005 trial of Lynn Stewart, a lawyer accused of aiding terrorists, to safeguard proceedings. Financially, the fallout is immediate. Sterling's firm has racked up over $12 million in fees per Federal Election Commission filings. Trump's legal expenses are public via campaign reports. 1-4, Bloomberg reported late Friday that the firm is in crisis talks with its malpractice insurer. Why? If the walkout leads to a mistrial or appeals success based on their actions, the firm could face lawsuits for negligence. Partners might be personally liable, exposing millions in assets. Insiders spotted senior partners at their Manhattan office until 10 p.m. Friday for an emergency crisis management session. This isn't just about money. It's about reputations built over decades crumbling in one ill-advised move. If you understand why this transcends one case, hit that like button. Here's the bigger picture. Allowing attorneys to walk out whenever rulings sour would shatter judicial integrity. Judge Caldwell nailed it. The court will not permit counsel to manipulate proceedings through calculated disruptions. Such tactics, if successful, would encourage every losing party to manufacture a mistrial through counsel withdrawal. She's spot on. Imagine a world where any defendant instructs lawyers to storm out, claiming unfairness. It erodes the adversarial system, rooted in English common law and enshrined in the U.S. Constitution. Historical parallels? Only 3 in modern federal history. 1. ***, 1978. Santo Traficante trial. ***, Mob lawyer Frank Regano tried to exit, faced disbarment threats. Trafficante, a mafia boss, was convicted. 2. *** 1992 BCCI banking scandal, ***. 2 attorneys attempted withdrawal amid fraud revelations, forced to stay under contempt threats. The bank collapsed, leading to global reforms. 3. *** 2009 Bernie Madoff case, ***. His team tried quitting mid-testimony, compelled to continue. Madoff got 150 years. In each, defendants lost, and lawyers faced repercussions, fines, suspensions, ethics probes. The pattern: courts prioritize continuity to avoid delays, exploiting the system. Politically, the reaction was swift. Trump's Truth Social post: "My lawyers are fighters who won't stand for this rigged trial. Judge threatening arrest equals election interference." It garnered 2.3 million views in an hour. GOP senators piled on. Tom Cotton tweeted about Banana Republic territory, but Democrats fired back. Elizabeth Warren: "No one is above the law, including lawyers sabotaging proceedings." A Reuters Ipsos flash poll Friday evening: 67% of Americans disapproved of the walkout, including 48% of Republicans. 72% agreed no one, even ex-presidents, is above the law. Even Trump ally Alan Dershowitz on Newsmax: "Walking out is indefensible. Use proper channels." When Dershowitz, who defended Trump in impeachments, balks, it's telling. Underreported detail: a defense paralegal anonymously claimed Sterling got a text at 11:42 a.m., 5 minutes pre-walkout, saying, "Abort Mission," from a senior GOP strategist. If verified, it suggests political orchestration over legal strategy. Judge Caldwell's Friday order echoed this. The court has reason to believe theatrical elements were coordinated with outside parties for purposes unrelated to justice. Sanctions threatened: contempt, fines, bar referrals. Security ramped up. U.S. Marshals to highest alert, extra NYPD, FBI on standby. A sidebar note warned of far-right militia near the courthouse. No threats, but added volatility. The judge cautioned teams against inciting disorder. Globally, reactions poured in. UK's ex-DPP: "Such behavior warrants custody." French media: "American justice in chaos." Russian outlets: "Proof of U.S. weakness." This erodes international faith in U.S. institutions, akin to how Watergate damaged global perceptions.